I will call to order the meeting of the Haverford Township Zoning Hearing Board for November 3rd, 2022. On the dais up here on my far left is Jessica Vitale, a voting member.
Good evening.
To her right is Ed McGargy, a voting member. To my right is Jesse Poynton, a voting member.
Good evening.
I'm Bill Rhodes, Vice Chair. To my left is our solicitor, Ernie Angelos. To the far right is Kelly Kirk, Township Zoning Officer. And on the side table is Margie Buchanan, the Deputy Zoning Officer. And before we get started, Jesse, you want to lead a Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America, to the republic which stands one nation, under God, indivisible, with liberty and justice for all.
Thank you. Ed, old business minutes?
Yes, we have minutes that were distributed for October 20th, 2022, and I recommend that they be approved.
I'll second that.
Any discussion? No? All in favor?
Aye.
Aye. Thank you, Ed. Thank you, Ernie. Okay, so we have one continued case and three new cases, but before we get into our continued case, one of the cases, I understand, is going to be continued. So we'll start with that one because we'll dispense with the case right now. So this is case Z22-24, I'm sorry, it's 28, I apologize. Which is James Miller, equitable owner of 2228 Haverford Road in Ardmore, Pennsylvania, DC folio number 220601067002, who seeks a special exception to construct a second floor addition which does not increase the footprint of the existing building to allow for offices to serve the existing uses as a natural expansion of a pre-existing non-conforming use pursuant to zoning code section 182-803B2 to establish Miller's Roofing business as the new tenant in the indoor storage building / warehouse use currently existing pursuant to 182-503B1E, and if necessary, a variance pursuant to 182-207.B1, and if necessary, authorization to make changes to the existing structure to replace a large lobby / waiting area on the first lot, which is no longer in use, with a new repair bay and the existing auto repair shop pursuant to 182-802B2. The property is zoned R5 and is in the 6th Ward.
Good evening.
Good evening. You're just going to make an announcement? Don't need to be sworn in at this point, right?
No, Mr. Ewald is counsel for the applicant. Prior to coming out, both the zoning officer and myself met with Mr. Ewald. There is a question in connection with the potential for additional zoning relief as it relates to parking. And I believe that the applicant, through Mr. Ewald, is going to request a continuance so that they can prepare a parking plan to the extent that they need to do so to show the required parking. And submit that at the next hearing, and/or catch up with the zoning officer to make sure what's required. Is that accurate?
Correct. And I think we were looking at December 1 as the next date.
Correct. So we would continue it, Vice Chairman, to December 1, and I believe the applicant was in agreement to waive all applicable time periods under the Township Zoning Code and the Municipalities Planning Code up through December 1.
Correct.
Okay, thank you.
That's easy. Thank you.
Thank you. Okay, so our continued case is,
I live next door to this property that you guys are going to rezone or try to rezone. Is there a way that I can get a blueprint of what it is that they're doing with regards to, pardon me?
Sure. Yeah, I just received Carl. Okay, so our continued case is Z 22-26, My Uncle's Gift, comma LLC, owner of 50 Cambridge Road, Haverford, PA, DC folio number 220400672000, who seeks variances from 182-727.b and c to permit portions of the proposed fence to be located within the front yard setback from the Tunbridge Road right-of-way, if required, a variance from 182-702 to allow portions of the proposed fence to be installed at the corner of Tunbridge Road and Cambridge Road, and any other relief deemed necessary to permit the proposed fence improvements zoned R1 in the Fifth Ward. This case was opened at a previous meeting and then continued to today, and the applicant has prepared, I think, to bring some additional information, right?
Correct.
And let me just, you were sworn, Julie Burns, right, Julie?
I'm counsel, so.
Yeah. So, okay, your client didn't get, you presented the case in
I
chief for your client.
presented,
Yeah,
and I have Ray Laughlin with me, who's the fence designer. He was sworn at the last
okay,
hearing.
all right. So Julie, why don't you tell us what the new information, and we should figure out, you've identified these as A-7-1 and A-7-2?
I did that quickly.
Okay.
A-7 was the fence plan from the prior hearing, so point 1 and point 2 will be the two variations on the theme.
Fair enough.
So, just as you may recall, at the beginning of the last hearing, it was our understanding that the property as a corner lot was allowed to be fenced along its secondary front yard in accordance with section 182-727.c4 of the Township Code, which provides that corner lots are permitted to be fenced along a secondary front yard as determined by the zoning officer. As the dwelling faces Tunbridge, and the driveway exits out of that side, and this Cambridge Road side functions as like a side yard. We viewed that as a secondary kind of front yard. However, as you may recall, Kelly, the zoning officer, advised during the last hearing that that was not the township's position. And I've since spoken with her, and she explained that the former zoning officer considered this zoning district to lack a secondary front yard on corner lots as opposed to the other zoning districts, because both of the front yard setbacks are equal in this zoning district, whereas other districts provide for a smaller setback on 1 yard of a corner lot. As a result, and based upon your comments from the last hearing, Ray Laughlin, who designed the fence and was here last time, and I went back to the owners who took to heart all of your comments, and they made significant revisions to the initial fence design to provide the security that was needed for the property based upon the existing conditions on this corner lot. So we have two revised designs, which, as I just mentioned, I pre-marked as A7.1 and 7.2. They're mostly similar to one another, but have minor adjustments that accommodate the existing grading on the property, which impacts the driveway gate, which I'll discuss shortly. So the first revised fence plan has more dimensions written on top, and I think I marked them in the opposite order. So the first one that I was going to refer to, just because it has dimensions written all over it, is actually A-7.2, and then the second revised fence plan has gates swinging towards Tunbridge, and that's marked A-7.1. So if you look at the two plans, the Tunbridge front yard fence has been substantially pulled back off Tunbridge on both of these plans. It basically tracks along the line of the 50-foot front yard setback line. Fencing on the setback line is permitted and doesn't require any relief. However, relief would be needed to permit the fence to bump out around the rotunda driveway that exists there. As previously discussed, this already encroaches into the front yard setback. Specifically, the fence would bump into the front yard setback by 8 feet. This would be 42 feet from the right-of-way and 52 feet from the cartway where a 50-foot setback is required. There's no sidewalk along this road, potentially because of the meandering stream that's along the frontage. So although this bumps out to encroach into the setback slightly, it's still more than 50 feet from the road. As previously discussed, fencing across this portion of the property would impede their ability to use the existing driveway, and a fence in the front of the home is necessary for the safety of the residents and guests, particularly given that meandering stream in the front yard, which drops down if you go up to it in kind of depth. And then again, because the residents are very concerned about the safety of their autistic nonverbal grandchild who regularly stays over with them. So then on the Cambridge side, this is true for both of these plans, which we view as the practical side yard of the home since the home faces towards Tunbridge. Both of these redesigns pulls the fence back substantially towards the house by 26 feet off the paved cartway. As you recall, since we believed this was permitted, a side yard fence would be permitted there, the initial design had this lining the road. But now it's been pulled back, and the location of the fence was placed here because of the existing landscaping and trees that are there and would all be preserved, as well as so that the area could be used by family and children, given the property layout and the needs to be fenced in for safety. The practical location of this side was determined by Ray Laughlin, who went back out to the site to kind of re-inspect again. So it's 26 feet off of the edge of the pavement. This is 30 feet away from the home, which the home actually goes all the way up to the setback already, so there would be no way to fence that side. And then we also note that if this wasn't a corner lot, the side yard setback would have been 20 feet. And Ray Laughlin didn't realize this, but where it is located, the fence as proposed would not encroach on what would have been a side yard setback if this was not located on a corner. So as previously discussed, the neighbor diagonally across the street from Cambridge does have a similar estate fence that's already lining the front yard, and the fence redesign here tracks behind a lot of the landscaping on Cambridge. If you wanted to flip back to Exhibit A6 where we showed the outside of this property, you would see all of this landscaping, so a lot of it will be obscured from the road. But to the extent that the part of the fence on Cambridge would be visible, it will fit in with the characteristics of this block. This then turns back and tracks along the front yard setback line on the Tunbridge side until that bump out that I previously discussed is required around the drive. Then finally, I'll get into how these two designs diverge, and this was in order to address grading issues on this part of the property, which impacts the swing of the entrance gate. So what you guys have marked as A-7.1 shows that the fence crossing the driveway on the fence front yard setback line causes the gates to need to swing out towards Tunbridge due to the grading. It can't swing into the property. And then a sliding gate also isn't practicable here because of the grading. So that's what led to the primary design, which I have marked as A-7.2. And this provides for the fence to bump out and down the driveway so that the gates can swing in towards the dwelling. The bump out would require relief to allow this section to enter the front yard setback specifically in the plan. The gate will turn to track down the driveway for 18 feet to where the grading allows the gates to swing in towards the home. In this plan, the gates will be located 32 feet from the right-of-way and 42 feet from the paved cartway at Tunbridge. Just as a comparison, the original design had this placed 25 feet from the right-of-way. This allows for plenty of space for a car to pull into the driveway and park in front of the gate. And the owners would agree to landscape kind of around this area to soften the way it looks. The redesign was created because it's the most practical due to the grading in this location and the logistics of guests who would be entering the property. But we are presenting as designed 2, i.e. the gate tracking along the front yard setback and the doors swinging towards Tunbridge as an alternate option, because despite this weird swinging gate issue, we don't believe it would be a safety concern as designed, given the length of the driveway. So the gates would swing out 7.5 feet towards Tunbridge, and that still provides plenty of space for a car or truck to be parked in the driveway with the gate doors open without needing to back into Tunbridge. So specifically, if the gates were fully open, there would be 42.5 feet to the right-of-way and 52.5 feet to the paved cartway of Tunbridge. The code provides that parking spaces should be 18 feet, so this is over 2 full spaces and approximately 3 full parking spaces to the cartway to allow something to back up away from the gate if that was necessary. The owners really appreciated the board's concerns when I talked to them. They really did take everything you guys said into account in this redesign, which still does require limited relief from section 182-727 due to the existing conditions of the property. It being a corner lot, which requires this dual frontage. The existing building or structure takes up basically the entire building footprint or buildable footprint, and the driveway, which encompasses the entire building envelope. So, as well as these grade changes on the property and the location of the landscaping, and the stream that meanders in the front, which they view as a safety concern. The Hertzberg Court advised that a variety of factors can be considered when you're considering a dimensional variance as opposed to a use variance. Here, the use is permitted, and so all that's being asked for is a reasonable adjustment from the code to allow for them to use the property around their house in a safe manner for their family. Here, we submit the significant changes to the plan were that kind of reasonable, even with the 2 bump outs in front and the encroachment onto the Cambridge side. We feel like this is in line with the neighborhood based upon the other estate fences in the area, and so it won't change the characteristics. And finally, it's just noted that in this new plan, there would be no need for relief from section 182-702, which regarded the visibility at intersections, because this is pulled back. So, as I said, Ray Laughlin's here if you guys have further questions.
Jesse, do you want to start with any questions?
I guess before we do that, just real quick, for purposes of establishing a record and the additional stuff, I'm assuming you would want us to move your exhibits into the record if we have not done so already.
Yes.
And then secondarily, you did provide some testimony in connection with the dimensions. You just want to have Mr. Laughlin just adopt
confirm
your-
that?
Yeah, adopt your
sure.
testimony.
Okay. So why don't you come up? You've already been sworn in, so you're still remain under oath, correct? So you heard what Julie has walked us through, right? Anything, would you adopt that as your own testimony if you were testifying right now? And anything you'd want to add to that or clear up or correct?
No, I think that was pretty concise.
Okay. Jesse, do you have any questions?
How strongly do they feel either way about option 1 or 2?
So my understanding is they do prefer, which I think is your option too.
Two, right.
So the gate swinging in towards the home, they feel that this is logistically more practicable for guests who are entering the property.
And I didn't follow the dimension, I couldn't write the dimensions down fast enough, but you can attest that in option 2, you can fit 1 car off the street before the gates, right?
Yes.
18 feet, okay,
Before the opened gates,
right,
all right?
Correct.
right. You don't have to open the gate to be able to pull off the street fully and get 18 feet.
Correct. That's true in both plans. There's plenty of space for a car
Right.
to park.
And in option 1, you said you could fit two cars could pull in off.
Correct.
Okay. I don't have any
Almost 3, I think.
No other questions?
Ed?
You know, I'm having a problem with the option 2, only because I did investigate the issue of the floodplain, and you're getting very close to the floodway of that creek, which is 50 feet. And I did talk to DEP, and it would require permitting to do that. So I would prefer option A7-1. As trying to stay as far away from the stream as possible.
So this one, just as a comparison, it was pulled back further from the road than the initial plan still. So that location is the closest to the home that it possibly can be in order for the gates to swing towards the house. So that really was what precipitated this plan, and why they prefer it. But again, they are comfortable with the other one. If you guys would provide relief for the other areas to make this like practicable and usable for them and to provide safety for the family.
But so would you
So-
accept the condition that,
It is.
yeah? So would you approve would you accept as a condition that A-7.1 be the approved option if so granted?
Yes.
That's all I have. Thank you.
Jessica?
Can you just confirm that on both Exhibit A 7.2 and A 7.1, facing Cambridge, there is a somewhat open triangular shape that looks like a gate? I just want to confirm that that is a gate.
Yes, I'm sorry, I failed to mention that. Yeah, it's a gate so that there's a safe way to kind of enter and exit the property.
And
It
that's
would
for both
maintain- It would be
options?
closed. It's in both
Okay,
options. Yeah.
thank you, that's all.
Anything else, Jessica?
No.
Okay, so, okay, thank you. So I wasn't sure if that was a smudge or a gate. Okay, and I would have, because the driveway is graded, or sloped downward towards Tunbridge, correct?
Correct.
That bringing it closer to the fence line and having it open towards Tunbridge would actually be a safer one, because otherwise, wouldn't there be a fairly large gap at the bottom of the gate so it could open inward? If you can open outward towards Tunbridge, which has plenty of places for a car to pull up, let the gate open outward, I would imagine there's less of a gap from the bottom of it to the driveway.
But which option are you talking about?
To the 7.A-7.
This one, yeah, this
Point
one,
one. Yep.
for it to be functioning, the case would have to.
When closed, though, it would be closer to the ground.
Yes.
Okay. Okay, and other than that, there's no changes, so we're still talking about a 4-foot-high estate fence, color black,
Correct.
along the Cambridge Road frontage and the Tunbridge Road frontage.
Correct.
And that other than the bump out for the gate, for the driveway gate, these are otherwise identical?
Correct.
Correct, okay. And so all the long discussion was really about the way the gate opened for the, or the fence opened for the gate on Tunbridge.
Correct.
Okay. I don't have any other questions. But do you have anything else you want to add before we open it up for public comment?
I guess maybe just to clarify, because we didn't say this, Ray, you prepared the two fence sketches that we submitted as A-7.1 and A-7.2, correct?
Okay,
Great.
all right. So before we close, I'll have to ask if there's anyone here from Haverford Township who received certified mail in this case would like to testify? Anyone from Haverford Township who received regular mail and would like to testify? Or anyone else from Haverford Township or otherwise in the room who would like to testify in this case? Okay, with that, we'll close the case and we'll try to render a decision tonight. We'll have to see how the rest of the agenda goes.
Okay.
If not, we'll render a decision at our next scheduled meeting, which is on November 17th.
Okay, thank you.
Thank you.
Thank you.
So if you wanted to stay, I'll call you or send you a letter.
Thank you. I
Oh, yeah, you
appreciate
can
that.
stay if you want, but there's no
Yeah,
guarantee
no,
we'll
no.
get to it. Okay.
Thank you.
Okay. Okay, so the next case on our agenda is Z22-24, New Singular Wireless PCS LLC, doing business as AT&T Mobility, lessee of 1808 Carricong Drive in Ardmore, PA, DC folio number 2206-0125400, who seeks a special exception from the provisions of 182.602.B3B to permit telecommunications equipment of a licensed provider in the INS zoning district and variances from the following provisions: 182-28.b to allow setbacks of less than 50% of the height of the tower from all property lines where 37.5 feet would be required. 182-602.c5 to allow a 12-foot side yard setback where 50 feet is required. 182-602.c6 to allow a rear yard setback of 8.25 feet instead of 75 feet. 182-728.c, I guess, to allow a chain link fence with webbing in lieu of the required landscape buffer around the compound. 182-728.g to not provide an annual certification of no change in operating characteristics. And 182-728.h to not require standards cited within the ordinance that are not applicable to the proposed facility. The applicant further requests that the board establish that the maximum impervious surface of 40% is legally non-conforming and that no new additional impervious surface will be created. In the alternative, a variance is requested from the impervious surface requirement of 182-602.c8 to allow for the creation of an additional de minimis impervious area of 135 square feet, and any other interpretations, waivers, and/or variances as may ultimately be required by the board. The property is zoned institutional INS and is in the 6th Ward. Welcome.
Thank you, Mr. Vice Chair. My name is Christopher Schubert. I'm the attorney here tonight on behalf of the applicant, New Singular Wireless PCS LLC, better known as AT&T Mobility. And just to kind of set the stage here, this is a proposal for a replacement monopole antenna support structure for AT&T's existing facility that is located to the northwest of where this location is at 1808 Carricong Drive. Unfortunately, the landlord of the other location and AT&T have a lease, and that lease is coming to an end, and the landlord did not want to renew that lease. There's currently an existing telecommunications pole at the back part of that property. That pole is about 90 feet in height. And what is being proposed here is a relocation of that cell site down to this property. We were able to, with sharpening the pencil, get this antenna height at the lowest height possible at 75 feet center line for the antennas instead of the 90 feet. Because of the nature of the maturity of the existing wireless network in the area, it would be very detrimental to any of AT&T's subscribers, businesses, and residents and constituents here in the township if that site were to go away and not be replaced with coverage. And again, because of the maturity of the network in this area, this replacement site has to be located in close proximity to the existing site. Otherwise, it kind of disrupts everything else in terms of the network. So I do have a number of witnesses here tonight that would be available to testify. Mr. Bill Leonard, who is with a company called Qualtech, who is the authorized agent for AT&T. He's the site acquisition consultant who is charged to go out and try to find the replacement site, and he can talk about those efforts, as well as the fact that we do have a lease agreement with the underlying property owner here at the subject property. Also tonight I have Andrew Peterson, who's the radio frequency engineer, who can talk about all the requirements under the Haverford Township Code and the need for this site, and that this site would comply with all the required FCC standards applicable to these types of installations. And then finally, I have Peter Albano, who is a licensed engineer with the Commonwealth of Pennsylvania, and he is familiar with the site plans that have been submitted with the application that detail the relief that is being sought by the applicant, as well as the existing site characteristics that are present. Now, I would have the ability, like I said, I do have the witnesses here tonight. If it is the board's pleasure, and there are no other parties who are interested in this application, I would be happy to summarize testimony to try to expedite the presentation. Of course, the witnesses would be available to answer any questions that the board members might have.
Well, let me just ask, is any members here in the audience here for this case, other than the applicant's reps? Okay.
And would that be the board's pleasure then?
Sure. We may have questions that you may.
Absolutely.
That you may want to defer to your other witnesses, and we'll swear them in as necessary. But feel free. Go ahead, Mr. Stuber.
All right, thank you. I have handed out exhibit packets pre-marked with the applicant's exhibits in support of this application. Of course, the application is incorporated by reference as Exhibit A1. I would have Mr. Leonard qualified as a site acquisition consultant and authorized agent on behalf of AT&T, who is authorized to appear here tonight and offer testimony. Mr. Leonard would testify that with regard to having leasing rights on that subject property, that AT&T and the underlying property owner, David and Barbara Fiacco, who are the owners of that subject property, have entered into a lease agreement, and that lease is in full force and effect and provides the ability for AT&T to move forward to secure any zoning entitlements that would be required for this installation.
Before you go, because it might be helpful, do you want to introduce your exhibits into the record and identify them for the record, what they are, just go down them, and then we can enter them, and then everyone can refer to them?
Perfect. So the first exhibit, A2, is the land lease agreement redacted as the financial terms. A3 is the CV of Mr. Peterson that I had mentioned. Andrew Peterson, PE, is a professional engineer, also with the Commonwealth of Pennsylvania. A4 are the abstracts of FCC licenses that AT&T has that authorize it to operate its wireless network in Delaware County and specifically Haverford Township. A5 is the radio frequency design analysis that Mr. Peterson prepared, which is dated September 15, 2022, which identifies the situation of having the existing site and the need for the replacement site and the supporting propagation plans that go with that. A6 is the propagation plan of existing reliable coverage that AT&T customers have in this area. A7 is a propagation plan that Mr. Peterson prepared that show reliable coverage without having the existing site that I mentioned at the property, which is northwest of the subject property here tonight. A8 is another propagation plan that Mr. Peterson prepared, which shows the reliable coverage with a replacement site, which is known as the Ardmore South Reload site at the subject property. Marked as applicant's exhibit A9 is a letter which is dated August 31st, 2022, which certifies that the minimum height necessary for the proper functioning of this replacement facility is at 75 feet center line, and that is authored and signed by Mr. Peterson. Marked as applicant's exhibit A10 is what is known as an electromagnetic exposure analysis that was also prepared by Mr. Peterson. This establishes that the site will be in compliance with all the applicable standards that apply to these types of facilities, in particular those standards adopted by the Federal Communications Commission. A11 is a non-interference certification that was also prepared by Mr. Peterson that says this facility will not cause any radio interference with any other radio-based technology. And finally, A12 is an FAA notice criterion tool, also authored by Mr. Peterson, that says that this facility, when placed at this location, will not violate any of the airspace requirements of the FAA. A13, actually, we have a replacement engineer. So A13 is to be replaced by A15, which is at the back part of your packets. And A15 is the CV of Peter Albano, who is a licensed engineer with the Commonwealth of Pennsylvania.
So A13 should be disregarded and A will only work off A15?
That's right. So I will withdraw A13, and we have A15 as a replacement. A14 are the site plans that were prepared by the engineer, which are dated July 6th, 2021, last revised October 4, 2022, which depict existing conditions and the proposed improvements to the property that would support the telecommunications installation. Now, getting back to the summary of Mr. Leonard's testimony, the site acquisition consultant, Mr. Leonard would talk about and testify about the existing telecommunications facility that I had mentioned, which is at the Nut House, which is to the northwest of this subject property, just a little over 1,000 feet away from the current location. He would testify that in looking at the ordinance, he knows that he would have to try to look for any existing alternate tall structures within 1,000 feet of the subject location, and he would testify that although he looked at 6 other properties, including an existing tower, which is to the southeast of this property, that none of those locations were either high enough or were too far away to satisfy the radio frequency engineer's needs in filling in this replacement site. In particular, with regard to the tower, which is to the southeast, that tower was also, had 2 other carriers that were already placed on it, and as a result of the height of that tower, those antennas couldn't be placed high enough on that tower, and it was well over, I think it was 3,000 feet away. Yeah, so it was getting close to.
Where's that tower that you were referring to?
Mr. Leonard, and maybe I should have the witnesses sworn at this point. And
Sure,
if
okay.
If there are questions, if everybody could be sworn.
So we'll start. Can you, why don't the first one come up? You, or the reporter, can you state your name and address?
Yes, Bill Leonard, and my address is 200 North Warner Road, and that is in King of Prussia, Pennsylvania.
And Mr. Leonard, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, yes.
Okay, thank you. Thanks. Hi.
Hi, Peter Albano, and my address is 2000 Mid-Atlantic Drive, Mount Laurel, New Jersey.
Okay, and Peter, do you swear to tell the truth, the whole truth, and nothing but the truth,
I do.
so help you God? Okay.
Evening. Andrew Peterson, address is P.O. Box 165, Fairview Village, Pennsylvania.
All right, Mr. Peterson, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Help you God. Yeah, thank you. Okay.
Now, Mr. Leonard, with regard to that, I believe it's a T-Mobile tower, which is to the southeast. Can you provide to the board a little bit more information about?
Or if you can point out where it's on some of these exhibits that were prepared by the engineer in some of these maps.
Why don't we reference,
Aerial.
A6 or,
yeah, A6. That helps.
It's down over here. It's like here.
Okay, so,
Or maybe that one's it, right there. Right there.
all right,
It's-
that's the subject.
Right, that is a subject. It's like here.
let me start. I presume the current tower is designated on Exhibit A6 as PAL 010178,
That's correct.
and the proposed one is identified as Ardmore South?
That's correct.
Okay. And the one you're pointing out there is, looks like it's over by the YMCA?
01049.
That's the closest one? Okay,
Yeah, that's the T-Mobile, AT&T's on it also.
okay.
Yeah, almost a mile due southwest.
And so PA 01009 would not work?
01049.
Yeah, 049, right, I see it. Okay.
And in fact, AT&T is already on that pole?
Correct.
Okay.
And there were no other physical structures, steeples, or anything that you could have tried to negotiate for placement?
No, I even looked at a rooftop, the auto body, but that wasn't tall enough, and they just didn't have the ability to lease the space even if they could.
And Mr. Leonard finally would offer that under the code that there is a restriction against having any signage, and there would be no signage on this proposed tower, correct? Except for anything that would be required by the FCC in terms of identification or emergency contacts, is that right? And also that he would be authorized to agree to any reasonable conditions that the board might see fit to impose upon grant of the application. Now, Mr. Leonard, is there anything over and above that summary of your testimony that you would offer here to the board? And would that summary of your testimony be accepted by you?
Yes.
And you would
You
adopt
want
as your own?
you want to repeat that? Because no one on TV can hear you unless you're talking to the microphone.
So you heard my summary of your testimony. Would you adopt that summary of your testimony as your own?
Yes, yes, I would.
And without any modification?
No.
Okay.
The question I have on the existing tower, which the lease wasn't renewed, were you the only provider on that antenna?
We were, yes.
So did you own the pole or did they own the pole?
I believe that it was a Pico.
You got to speak in the
I
microphone.
believe that it was a Pico pole, but the equipment was on the property of I believe it's the Head Nut was the business that's there.
Okay.
I don't know too much about it, but that's my understanding.
But will you remove all your equipment from that site now?
The equipment will be removed.
Thank you.
But the old pole is not yours and now stand empty at that spot?
I don't know about empty, but AT&T's equipment will not be on it. So if there is any, Pico electrical lines or anything that are there, obviously I would imagine that would stay.
Mr. Schubert, I think your testimony suggested that this new pole was a replacement pole. I think I heard you say. So it's not, it's an additional pole. Is that correct?
Well, it's only an additional pole related to the swap out of the antennas. So the antennas and all that are coming off of the Pico pole. AT&T doesn't own that pole. And my understanding is that it does support electric lines in that area.
So municipalities like this are presented with requests for potentially endless numbers of poles in there because the landlords and the tenants can't agree on rent? This is a rent problem, the Pico pole?
No, it's not a rent problem, it's a usage problem. The landlord doesn't like well, you can talk about what the issue is, doesn't like having the AT&T technicians coming up to the pole when it's open for business.
Correct. That is correct.
I presume that your technicians service the pole like any other wireless company would service their pole. In other words, there was nothing different about the way you service?
To my understanding, no.
Right.
Thank you. Thank you, Mr. Leonard.
Sorry, can I ask Kelly a question? So the pole that's remaining, presumably that variance to have the telecommunications equipment on top of it, correct?
That's a good question and one that I would have to look into.
Okay.
I don't know off the top of my head.
I'm just trying to figure out if, say, the owner of the pole decides to lease it to another telecommunications company, if that will be required to come in for a variance, or if they'll be able to put it back by right.
Likely, they would be able to put it back because a variance would follow the property. It wouldn't be specific to the carrier. So if that is the case, they do have a variance to be there, then yes. But I'd have to look at the file.
Okay, thanks.
And Kelly, if they fail to use that pole for 6 months as a telecommunication pole. Have they abandoned the use and would need a new variance?
Very likely.
So the next witness I would call is Mr. Andrew Peterson, the radio frequency engineer, and I would offer him as an expert in radio frequency design and analysis. And in fact, Mr. Peterson's report relative to this relocation site is marked as A5, and it would be Mr. Peterson would go through his report and talk about the existing coverage that AT&T currently has in the area from the existing site that we had talked about, the Pico site. And that propagation plan is marked as figure 1 in the report, and the larger exhibit is A6. And then with the decommission of that site, Mr. Peterson had prepared an additional exhibit which shows the coverage without the existing site in operation. And the larger exhibit of that plan, which is in the report, is marked as applicant's exhibit A7. And then finally in the report, the propagation plan shows the coverage from the reliable coverage from the relocated site on the subject property, and applicant's exhibit A8 is the larger version of that plan, which is contained within the report. And Mr. Peterson would testify that, based upon his analysis, that this would be an excellent replacement site, would fill in that gap that would otherwise exist with the decommissioning of the existing site, would provide reliable coverage for a great length of the roadway network, the residences and businesses along Carrigan Drive, and in addition, that SEPTA route, which is also a very important commuter route, would still have reliable coverage in that area. Mr. Peterson had also prepared a certification that's required under the ordinance, and that's marked as A9, which certifies that, based in his professional opinion, the centerline height of the antennas at 75 feet would be sufficient and would be the minimum height for the antennas that would be necessary to provide that replacement coverage. And again, as noted, the existing height at 90 feet is now able to be reduced to 75 feet in height, which certainly provides a benefit. Mr. Peterson would further testify that in doing an analysis as required under the ordinance, analyzing the site and whether or not it complies with the emission standards established by the FCC, he prepared the report marked as A10, and that in doing that report, his conclusion is that even if that site operated at maximum power with all the maximum assumptions associated with it, it would still operate at only 17% of the acceptable limit as established by the FCC. And the ordinance, I believe, also requires a detailed listing of the technical parameters, and those are set forth in terms of the frequency, power output, number of antennas, size of the antennas. That's all contained within his report. And then, in addition, he also prepared the report to establish that there will be no harmful interference caused by the operation of the site with other radio-based technology. And that's due to the fact that the FCC licenses and regulates the frequency at which these facilities can operate. Finally, Mr. Peterson would testify that in doing an analysis under the FAA screening tool that is available, that this site would comply with all the FAA requirements in terms of not interfering with any sort of air traffic navigation, and as a result would not have to otherwise be licensed or marked or have flashing lights on the tower, so the tower will not have to be lit. And then finally, Mr. Peterson would testify that AT&T is a licensed provider with licenses that have been issued by the FCC, and that pursuant to that licensure, AT&T is expected to adhere to all the rules and regulations of the FCC and also ensure that its customers have reliable service, which he would define as the ability of a provider, or I'm sorry, of a customer to be able to connect up to the wireless network very reliably and very robustly. So, Mr. Peterson, you heard my summary of your testimony.
Why don't we qualify
Yeah,
it?
can you just do quick, I know he's, for the record, I know the CV is listed as A3, but if you could just briefly qualify him, that'd be great.
Mr. Peterson, if you want to go through your qualifications.
Sure. Andrew Peterson. I'm a registered professional engineer in the Commonwealth of Pennsylvania, as well as a handful of surrounding states. I have undergraduate and graduate degrees in electrical engineering from Lehigh University, specifically a Bachelor of Science in Electrical Engineering and a Master's of Engineering in Electrical Engineering. I've been involved in the design of these types of facilities now for 20-some years, designed thousands of them over those years.
And you've testified as a radio frequency design expert in other municipal proceedings as well as court?
I have, yes, hundreds of times.
State and federal court as well?
Yes.
And your licenses are currently in full force and effect in Pennsylvania, and you're not subject to any censure or suspension of any licensures?
All correct, yes.
All right, so unless there's any objection, you qualify him.
Thank you.
Now, Mr. Peterson, you heard my summary of your testimony. Is there anything that you would add to the summary of that testimony?
There is not.
Would you adopt that summary as your own?
Yes, I would.
Does the board have any questions specifically of Mr. Peterson regarding the art design?
Jessica, any questions? From Mr. Peterson? Ed?
No question.
Jesse?
So, I mean, I just have a quick question just from, I happen to be an AT&T user for the last 20 years, and I happen to use this general area, and I've always found that there is a dead zone when you leave the Brookline station going towards the Penfield station. Do you feel that this tower in this new proposed location will help provide that coverage that seems to be missing along the train corridor, the SEPTA line there?
So that's headed south.
Yes.
Yeah,
towards
I mean,
69th Street.
this facility will provide a little bit better coverage toward the south. You can see that in the difference between the existing coverage and the proposed coverage.
You're on exhibit A8 or 9?
I'm looking at the design report, which I believe is,
Well, let's-
okay, yeah, if we look at the larger view, so I think it's 8, I'm sorry,
A6 versus
Eight.
A8.
yeah, A6 versus A8. You'll see just because we are moving the site 1,000 feet or so to the southeast, that strong in-building coverage, which would equate to, an in-train type of coverage. There's significant attenuation due to the physical properties of the train. Would be probably be pretty reflective of the green. So it is going to extend coverage further south. How much further south, that'll depend on the specifics, but it's going to help.
The green is a stronger signal. and
Yeah,
yellow
the
is a
green
weaker
is a
signal.
strong in-building signal. The yellow is an on-street signal. An in-car signal. So, being in a train is probably going to be somewhere in between. So tough to say exactly how far that reliable in-train coverage will extend, but I would say past kind of where you see green. Perhaps make the connection to the next site that would be off the page to the south.
And my only other question is, Kelly, if this was approved, this would all be reviewed, because this is a whole lot of information to get the night of the thing, so I'm going to have to trust that this is being reviewed by others, much more detail than we are going through it tonight.
So, right, it would need to go before the township engineer, for, structural analysis and code enforcement and whatnot.
Okay, thank you.
Okay, I don't, go ahead.
Yeah, no other questions about the coverage portion of it.
Okay, thank you. I don't,
Thank you.
Okay, thank you. And finally, the last witness would be Peter Urbano, who is the site design engineer who was involved with regard to the preparation of the plan and the review of the site plans that have been submitted with the application. And they are marked as applicant's Exhibit A14. And Mr. Abano would go through and describe the property. There is a tax and zoning map on the second sheet of that exhibit packet that shows an aerial view of the subject property. That property is currently an industrial, I think a car repair type business, which is located on a lot that does not currently comply with the minimum lot requirements under the INS zoning district designation. There had been some confusion with regard to the location of the property, which is shown on a survey plan on the next sheet, as to whether a triangular portion which is located to the immediate south of this property was also included on that property. And I understand that although the Delaware County Tax Office believes it is the owner's property and he's been paying taxes on it, and the tax parcel shows that those lots are connected, when you actually look at the deed and you go through the legal description on the deed, that triangular part of that property to the south is not part of this tract.
Do you know who owns it?
Probably the railroad. It probably came from a railroad. When you look at the tax parcel, you have the railroad that is immediately to the west. And when you look at that area, it looks like there's an access or service drive that comes up there off of Carrigan Drive to the railroad. So I suspect that the railroad owns it, but according to the tax office, the adjoining property owner, or the subject, the owner of tonight's property, which is the subject of the application, they believe they own it, and he's been paying taxes on it. So what is depicted is actually the lot, which is kind of a rough square. That property, the engineer would testify, is taken up mostly, if not entirely, by what would be considered impervious area, either paving or compacted gravel, which in his opinion, he would testify that most township engineers would view that as being impervious. And of course, the building. The building is also not conforming in terms of setback to both the southern side yard setback, the front yard setback, as well as the rear yard setback. And what is currently being proposed is the construction of a telecommunications compound at the southern rear of the property, near where the railroad tracks are at the back part of the property. The compound itself would be about 17.5 by 31 feet. That would 17.5 by 31 feet, which would be enclosed by a chain link fence in compliance with the township code at 6 feet. And then within that compound, there would be a concrete pad that would be placed, which would be about 13.5 feet by 10 feet. And on that concrete pad, AT&T would place its equipment cabinet, which they call a walk-in cabinet, which is roughly 6.5 feet by 6.5 feet square, and maybe about 6 feet, 7 feet in height. That would be connected up to the monopole antenna support structure, which would be placed also within the compound. Also on that concrete pad would be placed a 20-kilowatt emergency backup generator. The FCC, as a result of some of the adverse weather events, and especially since Hurricane Sandy, the FCC has mandated that a lot of these sites now have to be hardened in terms of having some redundancy so that if they were to lose power, there would be the ability of maintaining these sites and keeping these sites on air. So that would be the purpose of that generator.
Can I ask a question? All of this equipment, how high, you do realize the flood risk at this point, right? At that area of Caricong. So how high off the ground will all of this equipment be actually mounted,
Peter, do you know the answer to that?
including the backup generator?
So all the equipment's proposed at grade. There is a FEMA map reference on the plans. On sheet Z1, note 10 is the FEMA map reference. I do not know offhand what the flood elevation is at that point. But it's located in zone A and AE.
Okay, so just wanted to find out what the plan was. Okay, at grade,
Yes.
thanks.
And in terms of landscaping, one of the variance requests is that in lieu of landscaping around the base of that facility, that the applicant be permitted to install screening slats within the chain link fence. The reason for that is that this area, again, is all in impervious gravel, is not very conducive to planting any new landscaping in the area. And the property itself is essentially, although it's commercial, it's very industrial looking in aesthetic, having also the railroad tracks to the back part of the property, and the existing catenary poles that are used for electrifying the SEPTA rail line that goes back behind there. So from that standpoint, the applicant believes that the variance request from the landscaping would be warranted and that the screening would achieve the necessary screening from the adjoining road. In terms of the setback variances, the site plans describe the distances to both the side and the rear yards that are shown on sheet Z2. And those setback variances are summarized in the revised addendum that have been submitted with the application. So in terms of dimensional relief, under the code, there is a requirement that the tower itself be set back half the height of the tower from any adjoining property line. With the tower being 75 feet in height, the required setback would be 37.5 feet. The proposed setback for the tower to the rear property line would be 8.25 feet, 8.25 feet, requiring a variance of 29.25 feet. In addition, the setback to the southern property line would be 12 feet, which would also require the variance. The other variance that would be required, because the code also talks about compliance with the underlying area and bulk requirements for the underlying district. The side yard setback is required to be 50 feet. And again, that side yard to the southern property line would be a 12-foot setback for the tower. It's noted that there is already an existing non-conforming setback, both for the building to the side yard and also to the rear yard. At least with regard to the side yard, the extent of that non-conforming setback is not being added to. That tower will not encroach any further than the distance as to where that building is currently located. And then the dimensional variance is also requested to the rear setback. The standard for the rear setback is 75 feet, and again, as I stated, the building is not in compliance with that as it exists, and placement of the tower and the equipment would be at 8.25 feet to that rear property line. The other issue that came up in discussion is with regard to impervious surface and whether variance is needed for that. And with the revised request for relief, the applicant is seeking recognition by the zoning hearing board that essentially the property is already encompassed by 100% impervious, and that exists as a non-conforming situation. And adding additional impervious over existing impervious is not going to change that ratio. Alternatively, if the board or the township zoning officer or engineer don't believe that the gravel in the back represents impervious, then the addition of 135 square feet of impervious created by the concrete pad, as well as the tower, represents an additional de minimis increase in the impervious. Oh, and one other thing with Mr. Peterson's testimony that we needed to touch upon, and Mr. Peterson, sorry that I'm jumping out of order, but in terms of going down the list with regard to variances, the code talks about providing an annual certification of no change in operating characteristics on that facility. And while most of those would be correct in terms of number of antennas and height of the antennas, none of that would change. AT&T has the capability and also the obligation at times of changing or tweaking the frequencies at which the antennas operate, and also the antenna configuration can change as well. I would point out to the board that under Pennsylvania Act 191, the types of changes that are under the code in terms of you got to certify that there aren't any changes wouldn't necessarily comply with the current Act 191 under the state law in that regard. Minor changes that don't affect any antenna loading and are just changes in, say, frequency or slight adjustments in configuration can be done without permits currently under that state Act 191. So from that standpoint, it would be the applicant's position that those requirements do not apply and can't be complied with. And in the event that the board views that a variance would be necessary, the applicant would request a variance from that provision.
And if the applicant be okay if we didn't, if we were willing to give the other variances, but we were not willing to give that one, that would be okay with you?
Yeah, I think that would be okay because I know that Act 191 would consider it would preempt any inconsistent local ordinances. So that if there was, a change that didn't amount to a change in height or a change in the number of antennas, say, that we would be able to do that without having to certify to the township that no change would be made to that facility. And then finally, Mr. Peterson had pointed out that under the code, subsection H, and his report might address this, that although the site complies with a number of those, all those stated codes that apply to radio wave emissions, the one code or standard that is set forth, the International Radiation Protection Association standard, does not apply to these types of facilities. So that wouldn't be an applicable code. As pointed out in the report, that code only deals with what is considered ionizing radiation, the higher power like X-rays and those sorts of things, which is not applicable here. So again.
Yeah, so again, on that one, the concern would be inadvertently waiving things that we might not want to. So if it's not applicable to the proposed facility, I would want a very specific list of the ones that you would want a relief from rather than the blanket relief.
It's just the International Radiation Protection Association standard that's set forth there. Everything else is fine. Okay. And we will comply with all those other standards. It's just the one standard that does not apply. Now, Mr. Abano, you heard my summary of your testimony. Oh, and also with regard to the general criteria under the special exception, I don't want to forget those. Mr. Abano would further testify that as a professional engineer and having been involved in site design and layout of these types of facilities, that the general criteria for grant of a special exception would apply, that this property, given its characteristics, would be suitable for this proposed use, this additional use, that the installation would not detract from or have any a detrimental impact on the character of the surrounding neighborhood, given that it's essentially industrial in nature in and around that area. That obviously replacing this facility and relocating the facility so that wireless coverage can continue would serve the best interests of the township and its residents. That there's going to be no adverse impact on public services from this facility. There's certainly no need for water, sewer, anything of that nature. And that there's also going to be no adverse impact on highway traffic or anything would cause any congestion in light of the fact that maintenance on this facility would typically be scheduled once every 2 to 3 months. And you would have one single vehicle coming up and staying there maybe for about a half hour doing just some diagnostics and then leaving the property. And that there is no claim of financial hardship as a basis for granting this special exception. So with that, Mr. Bano, is there you heard my summary.
You're asking this as a licensed engineer, so you want to qualify him real quickly before he answers that?
Peter Albano. I am a graduate of Drexel University with a degree, Bachelor of Science in Architectural Engineering with a focus in structural, licensed PE in the Commonwealth of Pennsylvania, among 14, 15 others. 15 others.
And your CV, Mr. Bano, is attached and now marked as A15?
That is correct.
Okay.
And your licenses are currently all in full force and effect? You're not subject to any censure, suspension, or anything in any jurisdiction at this time?
That's correct.
Thank you.
And you've testified before zoning hearing boards and other similar boards in connection with engineering
Yes,
and before court as well?
not before court.
Any objection to qualifying him as a licensed physical engineer? Okay.
So would you accept my summary of your testimony as your own?
Yes, I would.
And is there anything that you would change or modify or add to that summary?
Yes, sir.
Does the board have any questions of Mr. Bano?
Jessica?
I would just ask if you agree that the International Radiation Protection Association standard does not apply to this site.
That is outside of my areas of expertise.
Mr. Peterson, could you confirm that?
Yeah, I would agree with that. That standards body is much more closely associated with practitioners in medical and nuclear fields than anything cellular.
Okay, thank you.
Ed?
Yeah, the questions I'm having are dealing with what the existing land use is of the building currently. Do you know how many businesses operate out of this building?
I believe, I know there's one.
Yep, you have to come up and speak in the microphone. And you might want to lift the microphone since you're relatively tall, so people
Sure. I'm only aware of one tenant in the building, just in dealing with David and Barbara Fioca. And that was in looking at the building, it was on the right-hand side of the building. I'm not sure about the other side of the building, I don't know.
Okay, that's problematic because the intensity of the use from the aerial photos that I've looked at looks like it's crowded with junk in the back of the building. Storage piles, stockpiles. I don't know that there's room to give up that space. For example, how would you access this site?
There is a gate around and a fence around that back portion. And there, as far as junk in the back, when we visited the site, it was cleared.
Okay, but your photograph doesn't show that. It shows some kind of structure coming off the back of the building as well.
That aerial, I believe, is probably a couple of years old.
Okay, but looking at from Caricon Drive, looking back towards the site, it shows a small gate on the one side of the building. Is that where you would have access?
As far as I know, there would be a new gated area.
Do you know the dimensions of that?
So the property is currently gated. The access would need to be provided through that gate, and then.
But it's not a vehicle access gate.
Correct. There is a larger gate on the opposite side of the building.
Okay, but do you have access around? I don't know, because the safety factors about getting around the building. From the aerial photo, it doesn't show that there is access around the building. So how will we verify that we will always have, with the intensity of the use there, always have ability to access the site with vehicles? Or the
Well,
buildings?
I might point out under the lease agreement that we are assured 24/7 access, so that would be the landlord's responsibility. If the board is concerned about that, I think that would be a reasonable condition to say that anything in the back part of that property has to be cleared out. I think Mr. Leonard has indicated that that's the current situation, but if the board wants to be absolutely sure about that, they can impose a condition that there has to be, anything that's back there has to be cleared out so that there's sufficient access, which is mandated under the lease that the owner has signed.
There's also a parking requirement for buildings in Haverford Township, which I don't know, that taking up space in a site that already doesn't have enough room, doesn't meet all the setback requirements, whether that standard is being met and the parking spaces are being taken up by this facility.
Yeah, and again, this facility is only visited once every couple of months. And anybody who would be coming up, and if the business is operating, it would be in lieu of a customer there. And any maintenance technician is only going to be there for 30 minutes.
Well, I don't mean your parking, I meant the existing building has parking requirements that we don't know whether they're even meeting their current parking requirements, or are they giving up parking spots to have your facility taking up spaces, not just people visiting and taking up additional
Are
parking?
you aware of any parking behind that building?
Behind the building? I am not aware of it.
Yeah, you're not aware whether or not they said to the zoning officer when they got their use and occupancy permit, whether or not they were going to have parking back there. We don't know. There's a lot we don't know about the property. Because I'm looking at the Google Earth map, I'm sorry, but I see more than one business on trucks outside. The tree service is another business that's sort of listed there, as well as a construction business.
That I'm not aware of any.
I don't know for a
I'm not
fact either,
aware.
but we don't know. That's the thing. We don't have the answers to these questions, so it's hard to make a decision.
Well, are you sure that that's not a use that's being conducted on the adjoining property? Because
Don't know. It
well, because there's only one building, and my understanding is that there's just the one tenant within the one building, two garage doors, and there is very close by on a separate property, another business in another building that is.
the catering business, right? There's a sign that says that anyhow.
Yeah, I'm not sure about the neighboring business.
Well, that was the questions I have, so I don't see how you maintain access. I don't know whether the safety factors have been met, whether we have a 10-foot setback, so we have emergency access behind all these buildings to be able to access during construction at the tower. So a lot of questions that remain to be, in my mind, aren't answered at this point by the application. That's all I have.
Bill, I have a few more
Yeah, go
questions.
ahead, Jessica, I'm
Sorry.
sorry.
No, that's okay. When you measured your setbacks from the rear and the side property line, what are you measuring them to?
What's listed on the plan is to the center of the pole, but what is mentioned is to the edges of the pole,
To the edges of the pole or the edges of the antenna?
the edges of the steel pole.
So how far do the antennas stick out from the pole?
They are typically 3 feet out.
Okay, so from the edge of the antenna, you would have then a 5-foot rear setback and a 9-foot side yard setback.
Well, I think
The
this.
antenna, are how high up in the air are the antenna attached to the pole?
The center line is at 75 feet, so they're up in the air.
Just curious. And then my other question was, the structure, or the pole is shown close to the edge of the existing building. Was anything explored to bring it further behind the building to comply with the side yard setback? Because there seems to be a lot of space behind the building where that could be located in a more centralized location.
Can you move it further back behind the building as to where it is?
I would imagine so. I would have to check with our A&E manager just to see if there's any issues with the landlord. I don't know. But I'm sure that we could. Oh, I see what you're saying. I think the shifting this way?
Yes, I just want to make sure.
Yeah.
Shifting plan north. Correct.
Right, you have to
Sorry,
repeat the question and repeat the answer, and you guys got to speak in the microphone.
The question was if the structure could be shifted plan north.
And confirm that that is the question.
Yeah, and I believe in talking with the landlord, because of the lease that he has with the individuals on the other side of the building, that we could not move it any further in that direction.
So then the property that is planned north of this pole is leased out to someone else,
Correct. That part of the building is leased out, yes.
including the rear of the building where there is no.
That is
visible-
correct, yes.
So then to Ed's question, how are you able to maintain access
And
to
parking.
that pole?
There is a gate along this side from off of Carricung Drive to the,
When you say this side, could you indicate directionally what side of the building, east, south, so for the record?
What exhibit are you referencing?
it is the overall site plan,
Part of A14.
A14.
Which page?
This would be Z1, overall site plan.
Z1, okay.
So looking to the south, off of Carricung Drive, that along the building, to the south side of the building, there is a walkway and there is a gate.
So
So there-
the access to that pole is the technicians would walk up to the pole. They won't be driving
They will
in
not be
close
driving,
proximity.
yes.
Okay.
And how wide is that at the narrowest point, which looks to be at the back edge of the building?
You know that?
It's more than 6 feet. More than 6 feet.
I don't have any other questions, Bill.
Okay. Jesse?
On exhibit A14, page Z2, which is named Site Elevation Compound Plan, the site elevation shows 3 strands of barbed wire above the 6-foot chain link fence. Are you aware that barbed wire is prohibited in the township zoning code?
Well, if that's the case, does the applicant need barbed wire? Can we do without?
You do not need it?
We do not need.
Okay, and you would
barbed wire.
accept that as a condition, to not have the barbed wire?
Yes.
Okay. I mean, I feel like we need to see a plan that shows the parking in order to really understand and review this, and also whether the 10-foot clearance is required. I think we need to know that too and see that on a plan so that we can really understand what's going on here. I don't have any other questions.
Yeah, I agree with Jesse. And for us to render a decision, we may want to leave the case open and have you guys at least submit some additional detail about the site plan, I would ask a question that, still in A14, on the page entitled Existing Conditions Plan, we show, or you show the contours of the land to the right of the subject property, which shows roughly a 8-foot drop towards the back of the property, dropping from Karakung towards the rail bed, which appears to just stop right at the property line. And is that because the property line has been dug down and the property is in fact completely horizontal or level?
That is correct. There is a retaining wall behind the property.
Retaining wall holds it all? Okay. And do you know the age of that retaining wall or its condition?
That I do not know.
Have you considered whether you need to upgrade that retaining wall given the equipment that you're putting in there, the investment you're doing?
I'm sure structurally they'll have to go through that exercise, yes.
And can you point out exactly where this, the floodplain statistics are in here? I'm sorry, you mentioned it, but
Just a note.
It's referenced as, in that same exhibit on Z1 as note 10. So that is that references the FEMA map. It does not state what the flood elevation is.
Ed, is zone X the real zone, or is that a placeholder? Like the date is shown XXX? Do you know?
The plan that I have is, we have.
given the history of Cobb's Creek flooding, I'd be very interested to see where Pico's or SEPTA's equipment is located along that rail line, and whether, knowing that they're elevating all their stuff along these waterways because of the flood experience that we've had in the last 20 years, you now have it, what you're building this on isn't just at grade, it's sunken. You've dug down to level it. It's now below the natural grade of the land. You're inside a retaining wall, so you're essentially building this in what effectively is a swimming pool, and putting all the equipment, including the backup generator, at grade. I just find it hard to believe that this is an area of minimal flood hazard, but Ed, if that's what it means, then,
Yeah, I get, well, the creek is on the other side of the tracks, and there's a retaining wall
yeah.
of
But
10 feet high, so it's possible that it's out of the floodplain.
it could be. I know that the water had gone over Karakung Road, right? It flooded the Karakung Swim Club and areas on the other side of the road, right? So.
Well, no, that's down further.
further.
Yeah.
Okay. So I know this isn't necessarily your business, but it's your site, and I don't know that we know how many tenants are in the building. It sounds like maybe just the owner runs a construction company out of it, is that right? Is that?
He's retired. David is retired.
So has he leased it now to someone else?
My understanding from what he told me is that he's leasing the one side of the building, the other side is not being leased.
Okay, when we talk about size of the building,
To the north side of the building.
Okay, so it's
from my
essentially-
understanding.
It has essentially several bays along the front of the building.
Yes.
And he's dividing the bays up, in theory, like some tenant has some bays, but not
Yes, sir.
all. And you do realize that each tenant would come with it a parking obligation to provide parking for its employees, for your customers. And we typically would want to know what the total number is to figure out how your use, which I acknowledge is not going to bring customers to the site. But it does call into question that, he's needs use and occupancy licenses for every tenancy, I think. Does he not, Kelly?
I'm sorry,
The
what was that?
property owner needs a use and occupancy license for each tenant, each commercial tenant. And do we know how many UNO licenses this property has currently?
Not off the top of my head, I don't know.
Okay. So we'd like to know that and then figure out, what are the added intensity of this, which may not be much, but it's clearly taking up some of the space. And if he needed it for parking for his other tenants, then it becomes a bigger issue.
So the issues I have are, and some homework that we would have going back is doing essentially a parking analysis, doing some further inquiries to the use and the tenants on that property, confirming access back to the compound, have an engineer go out, take a look at the retaining wall, perhaps throw a floodplain line on the plans and confirm what the floodplain elevation would be, just so.
That'd be great.
Because I think that AT&T would also have concern that if we are below the floodplain elevation, that we might want to consider doing a platform that's raised a little bit above that. So, they're the issues that I would have, and we go back and do some further investigation, come back next month.
I think the overall site plan on page Z1, you might want to incorporate the contours from the existing plan up to your retaining wall so that we can see the overall plan out when it's all done. And whether you have the ability, as Ms. Vitale suggested, of pushing this a little closer to the rear of the building as opposed to,
Plan north, so that you don't need the side yard relief anymore. That would minimize the relief.
And as part of the parking analysis, I would say it should be demonstrated on the plan, showing legal parking spaces and how it would meet. So not just an analysis of how many you need, you have to actually show us that it works on the plan with proper turning radius and entry access and egress.
and we don't know what the uses are, so we can't help you with how many parking spaces it's supposed to have until you get that kind of information.
I guess a question for Kelly would be, is if it's a vacant tenant, how do you determine the parking? Would it be from the last use?
It would be determined by the future use. So if this was taking up parking spaces, it could severely limit who could occupy the building after that.
And are you allowed to just abandon a use of a property in the township for something like this?
As far as not occupy the building,
Right, sounds like if they're not, if the south side of the leasable space is perhaps not intended to be used again, are they allowed to just kind of abandon it?
I mean, it's a building on private property. They would obviously need to either maintain it or demolish it or, upkeep it with regular property maintenance that's required at all properties. But yeah, I mean, it's a private building.
Okay, so but they would just have to we would have to determine the parking, so they might want to reach out to the township to find out what the parking requirements would be.
In addition, as long as there's no variances on that for the particular use, there wouldn't be an abandonment. If it's a by right or a permitted use, then no, that would continue to be permitted.
Okay. Any other questions? Ed, Jessica, Jesse? All right.
Investigation December 1st, I think is their next meeting. We'd have to find one that potentially is going to be problematic with regard to whatever the owner is doing out there. All right, well, that's good then. If there's no use except for one person, then figure out what the parking requirement is. Well, he will have to do that. Yeah, there's no parking requirement for that. It's just with regard to tenant use. He'll figure out what he's doing and let him know what the.
Okay. Mr. Schubert, anything else that you want to put on the record now?
No, nothing,
Okay.
nothing.
Thank you for the presentation. I will ask, I'll just open up for public comment, whether anyone from the township who received certified mail would like to testify in this case. Anyone from the township who received regular mail about this case want to testify in this case? Anyone else from the township or present in the room who would like to testify in this case? All right, so we will leave this case open, and we'll put it on our next meeting, which is on November 17th,
Oh, November 17th.
isn't it?
Oh, that's great.
Yeah, 2 weeks.
Do you think that'll be
You can go
sufficient
later
time?
if you want.
Yeah, that should be enough time.
Yeah,
right?
I think we
Okay, I mean, the next one after that would be December 1st, so.
Yeah, I think your preference, because I know
Yeah.
that they have a lease that is expiring soon.
Okay.
Okay.
So their preference would be to get sooner the better, so November
Okay,
17th.
if you change your mind or you need it,
Okay.
you know, you can call
I'll talk to
our
them.
solicitor or Kelly and let them know,
Sure.
right? But we'll put you in for 2 weeks from tonight, and feel free, you can come in and present the extra information. I don't know whether people may show up then with questions either about the new information or anything, but thank you.
Sure, thank you, Mr. Rose. Thank you, board.
Thank you, gentlemen.
Okay. Give me 1 second to make some notes. Yeah, please do. Right. Yep. So we'll just take a 5-minute break. Go off the record.
We're back.
Okay, so we're back, continuing the meeting of the zoning hearing board of November 3rd, 2022. Our next case is Z22-27, Lawrence and Michelle Tricana, owners of 513 Wales Road in Havertown, Pennsylvania, DC folio number 220102210000, who seek a variance from the provisions of section 182-208.C2F1 to construct a 16-foot by 11-foot elevated deck over an existing driveway that will encroach into the required 12-foot side yard setback by 6 feet, zoned R6 and in the second ward. Okay, welcome.
Thank you.
We're going to swear you in.
Sure.
One at a time. I presume you're Lawrence?
I am.
Okay. Lawrence, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, and your name and address for the record, please?
It's Larry or Lawrence Tricana, 513 Wales Road, Havertown, PA.
Okay. And Michelle? Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and address for the record, please?
Michelle Tricana, 513 Wales Road, Havertown, PA, 19083.
Okay, so you're both sworn in, so you both can talk, but just remember that she can only take one person at a time. So, okay, so you want to tell us a little bit about what you want
Sure.
and why?
Absolutely. So we're applying for the variance. The reasons we wanted to get the deck were the desire to stay in Havertown, the need for space, improve just the overall appearance of the property, and to keep up with our Joneses. Her sister lives next door to us. They came and did the same variance hearing of maybe 7, 8 years ago. We just want to match decks. I know that you're not in the business of matching decks, but I'll get to the point of the variance. When we first bought the property, we live on a large hill on Wales Road. The back of the property is on a slant, so the first floor of our house is at a second floor level as you walk to the back of the property. When we bought the house, there was already a stairwell built to help you get to the kitchen door on the side property. That step itself only comes within 2 feet of the property line when we first bought the house, and that was already something that was allowed in the first place. The main reason we're asking for the variance, we need to prove the unique physical circumstance or condition. In our case, it's the narrowness of the lot size. In the code, In medium-density residential district that we are in, we are considered a semi-detached, single-family home. The lot width in the code states that we are supposed to have a minimum 38-foot wide property, and all of the properties on our side of the street only have a 22-foot property to start with, wide width. That is my hardship that I'd like to bring to everyone. A few things about the property, or about the deck. Nothing would displease me more than anything gaudy or unsightly being put up around our neighborhood. Everything would be in coordinates with everyone else's decks. There is no parking issue that would come of any deck being put up. We park one car outside and one car out back, and always have. And lastly, I already said it, but it's really just a matter of trying to maximize space so we can raise our family and build a deck.
So the front of your house, just to put some context on this, well, why don't we do this question first? You have a kind of hand-drawn
I do.
plot
Yes.
plan, right?
Yes.
And you would like to mark this as an exhibit,
Yes.
right, and enter it into the record?
Yes, please.
Okay. So want to mark this as A1?
All right.
Are there any other of the information that you submitted that we don't generally require the application itself? You are the property owners,
Yes.
right? As evidenced by the deed. But you did submit 2 photos. Would you like this to be A2?
That would be fine.
Okay.
Yes.
And A2 is, A1 is,
Sketch.
correct me if I'm wrong, it's a hand-drawn.
Yes, just a sketch I drew of the property.
Overhead sketch of the property.
Yes.
And then A2 shows 2 pictures. Why don't you describe what these pictures
Sure.
are and what we're looking at here?
Sure.
Start with the top one.
When you come down Naylor's Run, there is an alley entrance to the back of the houses on Wales Road that wraps around to the back of the houses on Waverly Road. The top picture is coming up the alley from Naylor's Run. The deck that you start to see in the left-hand side of the picture up top is the property 511 Wales, and then my property has the van parked in at 513. The bottom is the same 2 properties, just a little bit farther up the hill.
Okay, and so the house 511 has a deck.
Yes.
Then we see your house,
Yes.
which shows like a basement window next to a garage door, I guess, right? Or a car pulled up to the back of the house in this
Right.
picture. And then the twin for
Yes.
you, is that, which has a very dark spot, is that another deck?
No.
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 The next house, which would be 517, not connected to me, they have a deck built.
Okay.
Yes.
Okay, so you're a triplex, you're building?
No, just a
No.
twin house.
Okay, so, but 513 and 515
Are
are the
connected,
twins?
yes.
Okay. And one of those is your sister's?
I
511.
apologize. So she is
She's 5'11",
5'11", the
okay.
previous one with the deck that you see on the left.
Got it, okay. Okay. Go ahead, I'm sorry. Why don't you describe, the second picture is just the same,
Right, it's the same alley, just a little bit farther up the road, where you can see my house to the right, 513, with the van parked in it, and 511
okay.
with the built deck.
So, anything else that you want to talk about the deck itself, or?
The deck, the idea of the deck is literally almost the same specs as they had. I don't plan on having any sort of anything really special built about it. It's really just to be elevated above the car. The car will still be parked in the same spot. And just to be able to walk out, I'm not sure if you can really tell from the picture, but because of the black and white. On the lower picture, where it says 513 Wales Road, just above the car to the left, you can see the steps that are pre-existing that allows you to walk from ground level up to the first floor of the where the kitchen door would be. That is the same height that the deck would be at, above the unfinished basement level and along where the kitchen window would be.
Are you connecting your deck to those stairs, or are you making a
That
new
would
opening?
yeah, they would connect the deck right to the stairs.
So in that case, would you actually be requiring a greater variance because your deck is only going to be 2 feet from the property line?
Well, this pre-existing steps are already there. I didn't assume that that would be considered part of the deck. The rest of the deck would then be coming out after it. I guess theoretically, there would be a diagonal turn that would, from where the steps meet at the back of the line of the property, there would be a diagonal turn to where the deck would then come out.
So
There
on-
wouldn't be a, I apologize, I didn't mean to cut
That's
you
okay.
off. There wouldn't be a continuous protrusion from the house where the steps end. I guess the answer would be it would just angle a turn until where the deck would then come out, where the property line is at 16. Theoretically, there must be at least a foot of diagonal, 2 feet of diagonal wood for me to be able to get to the deck entrance.
So just so I understand, Jessica, what the question you're asking is that they've asked for a 16-foot wide deck, but it's really 18 feet wide to.
Plus or minus, yeah,
Right, whatever the,
To fully link up with the
with the stairs.
top of the stairs, right?
Correct.
Yep. So it begs the question, I guess, Kelly, right? If from a public notice point of view and all that, that the dimensional variance would be that the deck is 4 feet into the side yard setback, but no more than the existing intrusion into the side yard from the staircase?
So steps and landings are permitted encroachments in the zoning ordinance. What would not be would be the full 11-foot length of the deck, if that's included in that 4 feet. A jut out for a landing for those stairs. If you need to get on the stairs somehow. So permitted projection, the rest, but if it's going the full length of 4 by 11 to the deck, then that would not.
yeah, we in no way had an intention of, like you see the 4-foot step protruding out all the way to the length of the deck. It would just be enough to make the turn.
Right. So the drawing of the proposed deck is not to scale, right?
Correct, yes.
So the idea would be that your stairs would add a landing of a couple feet wide to allow you to turn the corner onto the
Right.
deck, but the full length of the deck would stay in line with
With the 16 feet, yes.
and the current outer boundary or side of the house.
Yes.
Jessica, any other questions?
What type of railing are you thinking for your deck?
When I filled out for the permit, everything was going to be built out of wood. All the, I had all the schematics for the beam size and, oh, is it in here? I apologize. I didn't know I had a,
Are you, height-wise, is it just a standard railing height, or are you gonna have
oh, no, it'll be
any
the standard.
sections that are more like a dividing wall between you
No,
and
I
your
wasn't gonna
neighbor?
put any
Okay.
sort of dividing wall, just standard size.
Okay. And you don't have any plans to store anything under the deck
Nope, just parking.
outside of your car?
No,
And would you say that once you put the deck in, you'll still have adequate parking for 2 cars below the deck?
no, we never have.
You don't now? You can't
No.
fit 2 cars now? Okay.
I find if you try to do it, it encroaches on the neighbor, and it's just not neighborly, and you're
Okay.
parking in grass, and it's just not practical. We only park 1 car out back.
I don't have any other questions right now.
Ed?
The, looking at A2, and I'm seeing the sidewalk,
Yes.
you have a sidewalk stair like showing in.
Yes.
Is that owned by just your property?
That is, we determine the property line smack dab in the middle of the 2 of us. So it's a 4-foot alley between the 2 houses, 2 feet of it being our property line, the other 2 are theirs.
So you share that sidewalk then?
We do.
Okay. And the neighboring property, I think you said Waverly is a? the
Waverly is the next street up, but the alley in which the picture's taken from wraps behind our house and then continues to turn and wrap behind the following block up the street.
But the people across the alleyway don't share this alleyway, or?
No, across the alleyway would be the backyard of Gary and Janice. They live on Nailers Run.
Nailers Run.
Yeah,
So that's why you can show the whole driveway as about part of your property, 25-foot setback.
yes.
Okay, gotcha. And you would be able to place the post or your deck in such a way that it would not inhibit the ability to park underneath it?
Of course, not at all. Wouldn't even want to build it if it did.
No.
Promise that.
Yeah, because out front of your property, it's just on-street parking, right?
It's on-street parking
Yeah.
with a Irish bar around the corner. So I would not want to lose my parking spot if,
Gotcha.
in any way.
Right.
That's all I have.
Thanks, Ed. Jesse?
Yeah, sure. The deck at 511, would you estimate that that's also about 11 feet that you're proposing? Are you, to say another way, are you going to be essentially match the back?
It's essentially matching, I almost, again, the black and white picture, it's tough. You can almost see in the lower picture how their deck does have to protrude from where the steps and then immediately angles into the line of the house. We would copy that.
Okay.
And the same, probably the same spots where the posts were put in underneath also.
And do you have any plans to cover the deck in any way with a roof or an awning or anything?
No.
Would you accept a condition that you would not put a roof over it or enclose it in any way?
Sure.
And do you have any utilities planned for the deck? Utilities, I mean like electric or water?
Just you can see in the lower picture, there is just a motion light sensor when you come in. I would probably remove them both so the wood can come up flush to the wall, then turn it into an outlet so you could have any sort of simple outdoor outlet out there.
Okay,
Christmas
but
lights and such. I
No
guess.
other utilities other than electric?
No,
And you'd be okay with limiting it to that?
absolutely.
Okay. I think we already covered our other questions, so no other questions.
And so you won't enclose the area underneath the deck? You will continue to use it to park?
Yeah, of course.
Okay. And just so I understood, since I'm not an architect, the posts that are furthest from the house?
Yes,
That would be closest to the alley?
yes.
Are they going to be under the farthest corner of the deck, or will they be pulled back a little bit so the deck cantilevers over a little bit?
They would be I would assume pulled back ever so slightly, but I don't have an exact measurement of how far they would protrude, but I would, based on Lisa's and Greg's
They're just
house,
pulled back.
it's like less than a foot.
Okay.
And I can
So it's.
go get
it's-
that
it's
measurement if
pulled
you
ba-
like.
No, that's fine. It's pulled back, though.
Yes,
So it's
it
not
would not
sticking
be
all the way
exactly
out.
flush with the end of the wood of the deck.
Okay. Okay, and you're not planning to put any screening underneath the patio or anything
No.
like that? Or under the deck, I'm sorry?
No.
Okay, I have no other questions.
Okay.
So we'll enter into the record your exhibits A1 and A2.
All right, thank you.
Right? Do you want to enter in anything else? Do they need anything else?
No, I mean, what we could do is, if we wanted A3, just to put their application in.
Okay.
Short of that, yeah.
A3, you want to
Absolutely.
include your application with the deed, with the A3 being a 2-page application and a 3-page deed for 5 pages
Yes.
total? Okay. And is there anything else you'd like to include or
No.
tell us? Okay.
Thank you for making this not as intimidating as I thought it would be.
Okay, no problem. Yeah, so before we close the record, I have to say if there's anyone here from Haverford Township who received certified mail and would like to testify, seeing no hands or bodies, I would ask, is there anyone here who received regular mail who would like to testify? And is there anyone here from Haverford Township or otherwise in the room who would like to testify? There being no one else in the room, we'll close this case and we can try to vote tonight on this one. But you don't have to stay.
Okay.
And you can call Kelly in the morning and find out if we were able to do it or whether, if not, it would be in 2 weeks.
Okay.
Okay? And by the way, do you think you'll be able to finish this project within a year?
Absolutely.
Okay. All right. Thank you.
Thank
Thank
you.
you. Appreciate it.
14, half time.
All right. So why don't, Jessica, do you want to discuss this, or are you prepared to vote? Should we, I don't know, it's up to you.
Good night.
You too.
All right, so with that, Jesse, do you want to take this one?
Yep. Yep, with regards to case Z22-27, I would vote to approve the requested variance with the following conditions. Number one, that no roof be added or enclosure to the deck, that the parking of one car below be maintained, that no railings higher than required by code will be installed. The utilities will be limited to electricity only. The project will be completed within 1 year and in accordance with the notes of testimony.
I would also suggest that maybe the landing would be.
Yeah, I was actually going to add that the stair landing would be enlarged by the minimum amount required to allow a connection to the new deck.
Right. Okay.
Yep, I would accept that.
Okay.
So I would vote to accept it with that added condition.
Okay. Jesse, are you okay with that added condition?
I am, yes.
Ed?
Okay.
All right, I agree. That case is approved 4-0. And with that,
The fence one.
okay. Oh, yeah. So, okay. All right, so Jessica, with respect to our continued case, Z2226, are you prepared to vote?
I am.
And Ed, are you prepared to vote?
Yes, I am.
And Jesse, are you?
I am.
As am I. So Jessica, do you want to take it?
Sure, I would vote to approve the application, specifically option A 7.1, with the conditions that a 4-foot-high estate fence will be installed along Tunbridge and Cambridge Road, and that the fence will be completed within 1 year in accordance with the notes of testimony.
And the fence will be black?
Correct.
Okay, Ed,
I concur.
Jesse,
I concur.
as do I. The case is approved 4-0. Okay, so with that, we will adjourn tonight's hearing meeting. Thank you.